Welcome. I'm Sebastian Mahfood, and you're listening to WCAT Radio, the on-air wing of En Route Books and Media, bringing you the dulcet sounds of Catholic wisdom.
Hello and welcome. My name is Msgr. James Ramacciotti. I am the instructor for this online course of juridic structures with regard to the power of government in the Church. Let's begin with a prayer, shall we? Glory be to the Father, and to the Son, and to the Holy Spirit, as it was in the beginning, is now, and ever shall be, world without end. Amen. So to begin, I think it's important for us to define what we mean by canon law. It's an interesting term. Canon comes from the Greek word kanon, and that word has an interesting history. It was first found in Homer's Iliad, and the term canon, which now means a standard or a rule, originally meant or referred to those staves that held a shield together, that supported a shield. And so the idea that a law protected, supported, was a bulwark for the community to keep it together, to keep it strong, certainly is part and parcel of what law is for the community. So canon, which means a rule or a standard, has a very interesting, I believe, origin. And then, of course, law, in Latin, jus, comes from the Latin verb, the Latin infinitive jungere, which means to join, to bind. And again, it reminds us that all individuals in the community are bound together in a variety of ways, but certainly through our laws, because the law is for the good of the individual and really for the good of the community. So if we look at jus, law, maybe from three different perspectives. Number one, from its causal sense. So from its causal sense, jus is the sum or the collection of all laws. So in Latin we have the term jus, which means law. We also have the term lex, which means law. Lex would refer to a particular law, a particular statute, whereas jus would be the more generic, a broad term for law. So, for example, secular students in law schools in the United States, upon graduation, are awarded the J.D. degree, Juris Doctor. So they're the doctor of law, but law meaning the collection of laws, not simply one law. So jus in its causal sense is the sum total, the collection of law. And so this would be why we talk about the corpus juris canonici and the codex juris canonici, the body of canon law and the code of canon law. Jus can also be looked at from its formal sense, and its formal sense would be a right. So a right is a moral or a legal faculty of doing, possessing, omitting, or exacting something. Rights can be either perfect, that is, emanating from justice, or imperfect. Maybe a right is founded upon charity or some other virtue. Lastly, jus can be looked upon in its objective or its material sense, and that would be justice, the virtue of justice. And the great Roman jurist Ulpianus, Domitius Ulpianus, who was Praetorian prefect under Alexander Severus, his dates would be 208 to 235, Ulpianus gives us the definition of justice, which is the constant and perpetual desire to give to each person what is his due. So that would be the objective or material cause, if you will, of jus in the material or objective sense. Jus is justice. Let's look at Aquinas' definition for a moment of law. For Aquinas, law is an ordinance of reason. So one of the fundamental principles, anytime we look at the law, anytime we work with the law, anytime we strive to understand the meaning of the law must be reasonable. And so we have to presume that the intention of the legislator was indeed that the law be a valid law and therefore be reasonable. So obviously, any type of law, quote unquote, which would be immoral, for example, abortion, cannot, properly speaking, or a law which deals with an immoral issue such as abortion, all right, which would legitimize something intrinsically evil such as abortion, cannot, properly speaking, be called law. Why? Because it's unreasonable by definition. So, law is an ordinance of reason, and it's promulgated, and we're going to talk about promulgation in a little bit, but it's promulgated by the competent authority. Now, what does that mean exactly, the competent authority? Well, in the church, the competent authority, the competent legislator for the universal church would be two subjects. Number one, the Roman pontiff. Number two would be the College of Bishops. Now keep in mind that when I mention these two subjects of supreme authority in the church, I'm making a distinction and not a separation. Why? Because the Roman pontiff is the head of the College of Bishops. So we have these two supreme subjects of authority for the universal church. The Roman pontiff, the College of Bishops. They are legislators at that level. Locally, let's look, for example, at a particular church, specifically a diocese. The legislator would be, and only would be, the diocesan bishop, or those who would be equal in law to the diocesan bishop. Now, what does that mean? Well, the analog of a particular church, obviously, is a diocese, isn't it? However, we have other entities, particular churches that are not dioceses. So, for example, we have something such as an abbacy nullius. We have a vicariate apostolic. We have a prefecture apostolic. We have a territorial prelature. All of these entities would constitute particular churches. However, they're not dioceses. However, the individual who has canonical jurisdiction over these particular churches indeed is equal in law to a diocesan bishop, even though he may indeed not be a bishop. He may be, certainly has to be a priest, but he may or may not be a bishop. So all of these individuals, diocesan bishops, and those equal in law to diocesan bishops who have jurisdiction over a particular church, they would all possess legislative authority. With regard to other manifestations of legislative authority, provincial councils, for example, councils which would include the metropolitan of a province as well as all of the what we refer to as suffragant bishops, that is, diocesan bishops who had their own diocese but who are members of the province. These bishops can convene in a provincial council and legislate relative to laws affecting the entire province. That obviously would be legitimate legislative authority on a more local basis. And then, of course, a plenary council. In this day and age, a plenary council would consist of many provinces that would be geographically proximate to each other, usually within the same circumscription as an Episcopal conference. So a plenary council could legislate laws for the entire Episcopal conference, for the territory of the entire Episcopal conference, or ecclesiastical region, whatever has been determined by the Holy See. So these would be all manifestations of legislative authority and the exercise of legislative authority in the church. So law is an ordinance of reason. It's promulgated by the competent authority, and it is given for the common good. So the law specifically is for the community. This isn't to exclude the individual, but the law is for the community. Now, sometimes the law may be unjust or unreasonable for an individual given the individual's circumstances. Thus, ecclesiastical laws can be relaxed at times for a spiritual good, for a spiritual purpose, and we call this a relaxation of ecclesiastical law. We call this a dispensation. And if you look at Canon 85 in the Code, a dispensation is the relaxation, as the law reads, of an ecclesiastical law. Obviously, we cannot dispense from the natural law. We cannot dispense from divine positive law. We can't dispense from the Decalogue, for example. However, ecclesiastical laws can indeed be dispensed from in particular circumstances. So, this gives us our basis of law, law in the church. Obviously, the church is a living organism. We're a pilgrim people, as the Fathers of the Second Vatican Council so wonderfully articulated, and thus all of the people of God in the context of the church have rights, have obligations, have a role to play. And the law, canon law, helps us to clarify and to in an orderly fashion work the various roles of the various people in the church to assist them to work effectively. Now, when we speak of canon law, at least in this course, we're going to speak of canon law in a broad sense and in a narrow sense. In a broad sense, obviously, canon law is any ecclesiastical law. So, for example, there is religious communities, institutes of consecrated life, societies of apostolic life, all have their particular laws, their particular constitutions. And in a broad sense, this would constitute canon law. The specific laws relative to the functioning of the Roman Curia, to papal elections, to the process for servants of God being declared saints or beati. All of these laws would indeed, in a broad sense, constitute canon law. However, we're going to look at canon law in this course narrowly. And what I mean by that is, we're going to look at canon law in the strict sense, namely, only the law which is contained in the Code of Canon Law for the Western Church, for the Latin Church. So, when I'm speaking about canon law throughout the course, I'm going to be speaking of this in terms of canon law, which is found in the Code. So, let's begin, and let's open the Code to Canon 7. We're going to deal here with ecclesiastical laws. Always in reading the law, in striving to understand the meaning of the law and the intent of the legislator, it's very important that we are mindful of the context in which the law is written. So, Title 1 general norms, we're speaking specifically of ecclesiastical laws. We're not speaking of the natural law, we're not speaking of divine law, we're speaking of ecclesiastical laws. So I hope that this gives us at least a perspective initially. So we're speaking about simply church laws. So Canon 7. A law comes into existence when it is promulgated. Now what does promulgation mean? Well, promulgation really means the law is born, if you will. The law is made manifest. It comes on the scene. So a law is promulgated. That means that it is communicated and announced, if you will, to the community. Because law, as we just heard from our definition of law, is for the common good. It's for the good of the community, the good of the group. So law has to be announced. It has to be proclaimed. It has to be made known. It has to be made manifest. Let's look at Canon 8, shall we? Universal ecclesiastical laws are promulgated by being published in the official commentary Acta Apostolicae Sedis, unless another form of promulgation is prescribed for individual cases. These laws become effective only after 3 months have elapsed from the date of that issue of the Acta, unless they have binding force immediately from the very nature of the matter they treat, or unless the law itself specifically and expressly suspends its force for a shorter or longer period. So, the Acta Apostolicae Sedis is an official publication of the Holy See, and obviously this would be the venue to determine the importance of documents emanating from the Holy See, and certainly to determine what laws are coming forth from the Holy See. Now, it's interesting, the laws are promulgated, however, they do not become effective, these are universal laws, do not become effective until 3 months after the date of that issue. Now, that 3-month period of time, we call that in the law a vacatio legis, a vacation of law. And again, that is a mechanism in the law which is reasonable. It takes time for people to familiarize themselves with a new law, to maybe strive to understand the meaning of the new law and how to fully implement the new law. So we need some time to do that. Maybe a little homely example here will illustrate. Let's say in our locale, our municipality erects a new electric signal at a specific intersection. Once the electric signal is erected and initially becomes operational, the electric signal is not working fully. However, the yellow amber light is flashing. And the yellow amber light will flash, let's say, for a period of a month or however long it is for that jurisdiction. And that flashing yellow amber, that flashing amber light is a warning, if you will. It's an instruction to motorists that a new law has been promulgated and a new law is going to take effect, namely that at some time, at some point in the future, the motorist is going to have to probably stop at that intersection because the light will be operational, and if red is indicated, then you have to stop. But that period of time when the electric signal is flashing amber, that is a vacation of law. It's a time in which the motorist can familiarize himself or herself to the fact that a new law is going to be effective here. So that's the rationale for a vacation of law. For universal laws, it's 3 months. Let's look at paragraph 2. Particular laws are promulgated in a manner determined by the legislator, and they begin to bind 1 month from the date of promulgation, unless another time period is determined in the law itself. So, for example, Each diocese has its own law, its own statutes. And if the diocesan bishop wishes to promulgate new law, pretty typically he will do that usually through the diocesan newspaper or some other form of mass media. And again, after the law has been promulgated, there is 1 month vacatio legis, vacation of law, with which the people of the particular church have the opportunity to familiarize themselves with the law and understand that this law will be binding upon them in a month's time. Let's look at Canon 9, shall we? Laws deal with the future and not the past, unless specific provision be made in laws concerning the past. Canon 9 basically is articulating a fundamental principle that retroactivity is alien. It's contra naturam legis. It's against the nature of law. So, we know in our United States Constitution that ex post facto laws are unconstitutional. They're illegal. So, law deals with the future, not the past, unless there are specific provisions for this. Let's look at one such provision. Let's look, shall we, at Canon 1161. And 1161, I don't know if you've had marriage law yet, but Canon 1161 deals with what we call radical sanations. A radical sanation. Radix in Latin means root. A sanatio would be a healing or a cleansing, if you will. So it's literally a cleansing at the root. So if we look at Canon 1161, paragraph 1, this canon reads, "The radical sanation of an invalid marriage is its convalidation without the renewal of consent, granted by competent authority and including a dispensation from an impediment if there was one, and from the canonical form if it was not observed, and the retroactivity into the past of canonical effects." Now, what does that mean? Well, let's use an example here. We have John and Linda. John is a baptized Roman Catholic. Linda, let's say, is unbaptized. And John and Linda are in their early 20s and they're very much in love. And they come to the Catholic Church, and the priest or the deacon or the pastoral minister initially meets with them and judges that, well, they're really immature. They're really they're immature. There are some issues that need to be clarified here before they can proceed and enter into marriage in the church. So the church tells them to wait to enter into marriage. John and Linda don't want to wait. So John and Linda run down to City Hall and attempt marriage before a justice of the peace. So John and Linda exchange marital consent. However, it's lacking in form, number one, because John is obliged to follow canonical form. He's obliged to be married in the presence of a priest, deacon, or a bishop. And there's also a dispensation that's required, what we call a dispensation from disparity of cult, because Linda is unbaptized. So let's say a number of years have passed, and there's a child on the scene. And John comes back to the church and says, okay, I have a 5-year-old child. I'd like the child to be baptized. I would like to be, I would like to practice my Catholic faith again fully, but I have a problem. And my problem is I'm not married in the eyes of the church, and my spouse, Linda, who is certainly open to our child being baptized and certainly supportive of my practice of Catholicism, she believes that we indeed are married, and she has no desire and no inclination to renew consent before a sacred minister in the church. What do? Well, a ratiocination could be granted in that the church would, again, retroactively sanate that union of, let's say, 5 or 6 years earlier. And therefore, after the ratiocination has been granted, as far as the laws of the church would be concerned, John and Linda would have married indeed 6 years earlier. Why? Because the action's retroactive. Now, obviously, the granting of a ratiocination should be and is an extraordinary event, and certainly should be, because it violates the very nature, really, of law. However, there is a spiritual good at play here, namely that John can live out his Catholic faith, that a child is going to be baptized in the Catholic faith and hopefully be raised in the Catholic faith and live out the Catholic faith. So there are spiritual goods here that would urge the granting of such a request by the church. So this would be an illustration, or a ratiocination would be an illustration of retroactivity with regard to the law. Let's look at Canon 10, shall we? Canon 10 reads, "Only those laws which expressly state that an act is null or that a person is incapable of acting are to be considered to be invalidating or incapacitating." I would like to draw your attention to the word expressly. Expressly may be misleading. Expressly does not mean explicitly. Expressly can mean implicitly or explicitly. Allow me to illustrate. Let's look at Canon 1 of the Code. Canon 1 reads that the laws of the Code affect only the Latin Church. Okay. That canon expressly states, albeit implicitly, that the laws of the Code, the canons of this Code, do not deal with the Oriental rites of the Catholic Church. So that law expressly states that, albeit implicitly. So only those laws which expressly state that an act is null or that a person is incapable are to be considered invalidating or incapacitating. This Canon 10, again, expressly states the intention of the legislator, namely that the presumption of the law is that people are capable and that acts are indeed valid and lawful. That's the presumption. A presumption in law is a probable conjecture of an uncertain fact. In other words, when we speak in general of presumption, the notion of presumption in law, and this would include common law as well, civil law, it's a probable conjecture of an uncertain fact. In other words, it's rebuttable. There's a maxim in the law, presumptio cedit veritate. Presumption yields to the truth. So a presumption may indeed be erroneous. However, the presumption is, the rebuttable presumption by the legislator is, that generally speaking we're going to presume that acts are valid and lawful and that persons are indeed capable of acting. So the exception would be an invalidating or an incapacitating law. Let's look at this. With regard to an act is null, all right, let's look over here, shall we, at Canon 849. This deals with the sacrament of baptism. Canon 849 reads, "Baptism, the gate to the sacraments, necessary for salvation, in fact, or at least in intention, by which men and women are freed from their sins, are reborn as children of God and configured to Christ by an indelible character, or incorporated in the church, is validly conferred only by washing with true water together with the required words. All right, that canon tells us expressly that if water is not used with regard to baptism, the act is null and void. If the required words are not used, the act is null and void. So, if someone were to attempt to baptize an individual with oil, for example, well, in terms of Canon 10, that act would be null. If someone attempted to baptize one with water, however, they did not use a Trinitarian formula, they baptized someone in the name of the Lord Jesus, that act is null. So these laws such as this, deal with the action itself and not per se the person. Let's look at the term incapable. Now, in the law, there are two terms that we would use relative to a person's incapacity. The first term would be in habilis. In habilis. In habilis basically would be the effect of an impediment. So let us look again with possibly with regard to marriage. All right. So a person, a baptized Roman Catholic, is in habilis to enter into marriage with an unbaptized person. That's Canon 1086. So in habilis refers to the fact that a person is per se capable, but the law, for whatever reason, renders them in habilis, incapable. However, the person intrinsically is capable. So obviously, according to the natural law, a Roman Catholic certainly could enter into marriage with an unbaptized person, again, all things being equal relative to capacity and the exchange of consent. There is also an incapacity which the law delineates, and this would refer to in caupax. In caupax. So we have in habilis, the person's per se capable, but the law hinders them, if you will, impedes them from the act. And then we have a situation where a person is in caupax. In caupax means the person is per se incapable. Incapable. For example, Canon 1095 states that individuals are incapable, that is, in caupax, of entering into marriage if they lack due reason, they lack sufficient reason, if they lack due discretion of judgment, or if they are unable to fulfill the terms, the objects of marriage, the obligations of marriage, due to psychological reasons. So these would be psychological anomalies which would render a person per se incapable. And a person who is per se incapable is in caupax. Let me use another illustration. If you look in the section of the code relative to procedural law, Canon 1550. Canon 1550, Section 2, delineates those individuals are absolutely, radically incapable, that is, in caupax, from offering testimony before an ecclesiastical tribunal. Such a person would be a confessor relative to any matters that he knew by virtue of the sacrament of penance. So, a person is, in that circumstance, is not simply in habilis, impeded, but they're radically incapable. So, only those laws that expressly state that a person is incapable of acting are to be considered invalidating or incapacitating. And hopefully we will see these illustrations of this throughout the course. Let's look at Canon 11. Merely ecclesiastical laws bind those baptized in the Catholic Church are received into it, and who enjoy sufficient use of reason, and, unless the law expressly provides otherwise, have completed 7 years of age. So, merely ecclesiastical laws. Obviously, everyone is bound to follow the natural law, and everyone is bound to follow a divine positive law. So for example, everyone, all humanity, is bound to follow the prescriptions of the Ten Commandments, obviously. So, but merely ecclesiastical laws bind only those baptized in the Catholic Church, are received into it, and enjoy the sufficient use of reason. So this is a fundamental change from an earlier ecclesiology in which non-Catholic Christians were looked upon, in large measure, as either heretics or schismatics. So this canon reflects the ecclesiology of the Second Vatican Council, in which the fathers of the council delineated, all right, what constitutes the Church of Christ and who is a member? Well, obviously, baptism incorporates us into Christ and into the Church. However, some who are baptized, who are not, may not be in full communion with the Catholic Church, they are members of the Church of Christ in this generic sense, but they are not specifically members of the society which constitutes the visible church here on earth, which subsides, which in the or resides in the, subsists in the Catholic Church. So these ecclesiastical laws deal with only Catholics, baptized Catholics, or those received into the church, and those who have use of reason. So normally, chronologically, this would mean those who have completed 7 years of age, or certainly individuals. There are some individuals who may have some type of mental difficulties, psychological difficulties, where chronologically they may have reached majority, they may be 18, 20, etc. They may be an adult chronologically, but psychologically they would be reckoned as an infant. So, let's look at Canon 12. Canon 12 deals with territory. All persons for whom universal laws were passed are bound by them everywhere. So all persons for whom universal laws were passed are bound by them everywhere. Number 2. However, all persons who are actually present in a certain territory are exempted from universal laws, which do not have force in that territory. Let's illustrate. I am sitting here in St. Louis, and we have a wonderful, wonderful Italian section of the city of St. Louis called The Hill. It's a wonderful place for great Italian cuisine and Italian culture. So, let's say that my cousin is visiting me from Rome. And let's say that it happens to be the feast of Saints Peter and Paul, the solemnity of Saints Peter and Paul, which is, according to Canon 1246, a universal holy day of obligation. All right. Now, my cousin is with me in St. Louis on that solemnity. He has a domicile in Rome, but he is actually here in St. Louis. And in the United States, the solemnity of Peter and Paul is not a holy day of obligation. So according to Canon 12, paragraph 2, since my cousin is actually in a territory exempted from universal law, he's not obliged to go to Mass. Conversely, were I in Rome on June 29th for the solemnity of Peter and Paul, that is a universal holy day of obligation, Let's say that we're not exempted, that it's an obligatory holy day of obligation. Well, because it's a universal law, I would be obliged to attend Mass, to go to Mass in Rome. Let's look at Canon 3. Section 3 of Canon 12. With due regard for the prescriptions of Canon 13, laws established for a particular territory bind those for whom they were passed when these persons have a domicile or quasi-domicile there and are likewise actually present in the territory. Now, this canon is based upon Germanic law. Germanic law is one of the sources, one of the fontes, as we call it, of canon law. And Germanic law gave us the notion of jurisdiction as being tied to territory. Roman law did not have this construct necessarily, but Germanic law did. So jurisdiction is tied to territory. So, for example, a diocesan bishop has canonical jurisdiction in his diocese. Now, when he is not actually present in his diocese, he still has some powers by virtue of the law, but he does not have the power that he would have, the jurisdiction that he would have, as if he were in his own territory. So the idea of jurisdiction, generally speaking in the church, and obligations, laws, are territorial. And that principle of territoriality comes to us from Germanic law. So particular laws established for a territory bind only those parties that have a domicile or a quasi-domicile there, and the people are actually present in their territory. Now, let's look briefly at what we mean by a domicile or a quasi-domicile. If we page over to Canon 102, paragraph 1, a domicile is acquired by residence within the territory of a certain parish or at least of a diocese, which is either joined with the intention of remaining there permanently, unless called away, or has been protracted for 5 complete years. So that would constitute a domicile. Quasi-domicile is acquired by residence within the territory of a certain parish or at least of a diocese, which is either joined with the intention of remaining there at least 3 months, unless called away, or has in fact been protracted for 3 months. That would be how the law understands domicile or quasi-domicile. Let's look at Canon 13, shall we? Particular laws are not presumed to be personal but territorial, unless it is otherwise evident. So the presumption of law is that particular laws are territorial. And we have to read that in light of the earlier canon, Canon 12, with regard to a person's domicile, quasi-domicile, and their actual presence in their territory. So, let's look at paragraph 2. Travelers. Now, what do we mean by a traveler? A traveler, peregrinus in the law, a traveler is someone who possesses a domicile or a quasi-domicile, but does not happen to be in their domicile or quasi-domicile at a particular time. So I have a domicile in the Archdiocese of St. Louis. However, I am on holiday with my family in Washington, D.C. So I am a traveler. I am a peregrinus in Washington, D.C. Someone who neither has a domicile or quasi-domicile would be referred to as a vagus, a vagrant. So a vagus or a vagrant would be a traveler, if you will, but it would be someone who has no domicile nor quasi-domicile. A traveler does, they just happen not to be there. So, going back to paragraph 1. Particular laws are not presumed to be personal but territorial unless it is otherwise evident. Travelers, section 1, are not bound by particular laws of their territory as long as they're absent from them, unless their violation would seize would cause harm in their own territory or unless the laws are personal ones. That's reasonable. Let's look at Section 2. Travelers are not bound by the laws of the territory in which they are present, with the exception of those laws which provide for public order, which determine the formalities of legal actions, that's a fancy way of saying contracts, or which deal with immovable goods situated in that territory. So immovable goods situated in a territory would be property, buildings, such as that. Let's look at paragraph 3 here. Transients, that is vagi, are bound by both universal laws and particular laws which are enforced in the place in which they are at present. So, transients, vagi, since they have no domicile nor quasi-domicile, basically are subject to the laws of the territory in which they find themselves. Okay, again, these things are reasonable. Let's look here at Canon 14, shall we? When there is a doubt of law, laws do not bind, even if they be nullifying and disqualifying ones. When there is a doubt of fact, however, ordinaries can dispense from them. In the latter case, if it is a question of a reserved dispensation, the ordinaries can dispense as long as the dispensation is usually granted by the authority to whom it is reserved. Let's look at this issue of doubt, dubium. What is doubt? Well, a doubt is a suspension of judgment. Why? Well, we suspend judgment because, quite honestly, we don't have enough information. Now, doubt can be either positive or negative. Negative doubt is equated in the law with ignorance. We just don't know. Positive doubt, however, is that doubt in which, all right, we have knowledge, we have some knowledge of the facts. However, the knowledge is insufficient. Let me illustrate. We have a doubt of law. Let's look over here at Canon 9:17. Canon 9:17 deals with the reception of the Eucharist. And Canon 9:17 reads, "A person who has received the Most Holy Eucharist may receive it again on the same day, only during the celebration of the Eucharist in which the person participates, with due regard for the descriptions of Canon 9:21, paragraph 2. Now, some translations will not use the term again. They will use the term a second time. Now, that is in light of an authentic interpretation given by the Pontifical Commission for the Authentic Interpretation of Legislative Texts, because there was a doubt of law relative to Canon 9:17. And the doubt of law basically centered on one Latin word in the text of the law, and that Latin word was iterum. Iterum. Iterum means again. It also means a second time. Now, if you were to read the law using the term again, one could quite reasonably deduce from the law that a person, as long as the person attends Mass, could, in theory, attend 10 Masses a day and receive the Eucharist. All right. That doesn't sound reasonable. That doesn't sound exactly right. So, an inquiry was made to the Pontifical Council for legislative texts, and the Pontifical Council, which is charged with authentically interpreting the law, said that iterum, or responded, that iterum means a second time. So, if we read that canon from this perspective, a person who has received the Most Holy Eucharist may receive it for a second time on the same day, only during the celebration of the Eucharist. The law here is clear that an individual can only receive the Eucharist twice in the course of a day in the context of the celebration of the Eucharist and the celebration of the Mass. Again, with the exception of Canon 921, which would be possibly viaticum, the person's in danger of death. So, this illustrates a doubt of law. A doubt of law means that there's a doubt with regard to the meaning of the law, or that there's a doubt with regard to the existence of law. Does such a law exist? Let's talk about a doubt of fact, shall we? Let's say that an individual has no documentation relative to his baptism. So, an inquiry is made. Do you have any idea if you were baptized? And he says, well, my parents were Mormons, all right, but we never attended church. All right, that would seem to indicate that the person is not validly baptized. Obviously, the church does not accept Mormon baptism as valid baptism. So that would be an indication that the person is not baptized. However, the person may say, well, when I was a child, when I was very young, I spent many weekends with my grandmother. And my grandmother was a very, very devout Christian woman. She was a devout Baptist, and she took me to the Baptist church every Sunday. And I remember, I was very small, but I remember, I think I may have been baptized at the Baptist church. So, you see what we have here. We have a doubt of fact. There is reason to affirm proposition A. There's reason to affirm proposition B. Well, there's some evidence that I was baptized. There's some evidence that I was not baptized, according to the person. So there's still this doubt. There's still this withholding of judgment, all right, suspension of judgment, because there is insufficient knowledge. We don't have enough information. So, Canon 14, when there's a doubt of law, the law doesn't bind. When there's a doubt of fact, ordinaries can dispense from them. So, let's say this individual, whose baptismal status is unknown, wishes to enter into marriage in the Catholic Church with a Roman Catholic. Okay? We can ask the ordinary to grant a dispensation. It's called the dispensation from disparity of cult. That means that a Roman Catholic is entering into marriage with an unbaptized individual. And the dispensation can be granted what we call ad cautelam. That means for cautionary reasons. So, if it's necessary, the ordinary can dispense. I'd like to look at that term, ordinary. That is a term of art that we use in the law. If you'll page over to Canon 134, Canon 134 articulates what exactly we mean by the term ordinary. If you look at 134, paragraph 1, by the title of ordinary in the law are understood, in addition to the Roman pontiff, diocesan bishops and others who, even if only on an interim basis, have been placed over a particular church or over a community which is equivalent to it according to the norm of Canon 368. Those would be the individuals whom I chronicled earlier in our discussion here today. Those individuals that would be equal in law to diocesan bishops, but may indeed not be of the rank of bishop or be in charge of a diocese. They would be in charge of a particular church and nevertheless be equal in law to a diocesan bishop. So they are ordinaries. Also, those who possess ordinary general executive power in said churches and communities, namely vicars general, episcopal vicars, and likewise for their own members the major superiors of clerical religious institutes of pontifical right and of clerical societies of apostolic life of pontifical right, who possess at least ordinary executive power. So, all of these individuals that are chronicled in paragraph 1 are ordinaries. So frequently when we hear the term ordinary, we simply think of the diocesan bishop. That's not wrong, but the term is generic. So it can include, and it does include, a variety of peoples. Now the law makes a distinction between ordinary and local ordinary. If you look at paragraph 2, by the title of local ordinary are understood all those mentioned in paragraph 1, except superiors of religious institutes and societies of apostolic life. So, the provincials of of clerical institutes of consecrated life or societies of apostolic life, they're ordinaries to be sure, yes, but they are not local ordinaries. They are not local ordinaries. Now, what does this mean in Canon 134 when it describes those who possess ordinary general executive power? What does that mean? We have a tripartite division of government in the church and in the civil realm, namely legislative, judicial, executive. Legislative authority, judicial authority, executive authority. Legislative authority, the person is capable of making laws, promulgating laws. Judicial authority, a person is capable of judging specific laws and the application of the law in specific instances with regard to specific persons. Executive authority, those whose charge it is to carry out the laws, to implement the laws. Now, the power of governance, which is involved in these three manifestations of authority, can be exercised either by ordinary power or by delegated power. When you hear the term ordinary power, ordinary authority, remember that ordinary means that the power emanates and the power is attached to an office. An office. So a person has ordinary authority, ordinary power of governance, and again, it may be legislative, it may be judicial, it may be executive, by virtue of a specific office which they possess. So, a diocesan bishop has this power of governance. Why? Because he possesses the office of diocesan bishop. Now, ordinary power can be either proper or vicarious. So, the diocesan bishop possesses proper executive authority in his diocese. He is the proper executive. He is the one who executes, who carries out the laws. Now, he associates to himself others who possess ordinary power, ordinary executive power, but this ordinary, which is linked to an office, but this ordinary power is vicarious. In other words, these other individuals are carrying out this ordinary power from their office in place of the bishop. Vicarius in Latin means a substitute. So, someone who possesses ordinary, vicarious, executive authority in a diocese would be someone such as the Vicar General. A sort of modified form, if you will, a diminutive of the authority of a Vicar General would be, and we'll see this later in the course, would be what we call an Episcopal Vicar. These individuals possess an office in the church. They possess ordinary executive authority in the church. The diocesan bishop is the proper judge in his diocese. He has proper, ordinary judicial authority. There are others who have an office who share that judicial authority, that ordinary judicial authority in the church vicariously. We call these individuals the judicial vicar. They're also known as an officialis, or adjutant judicial vicars. We also refer to them as vice officiales. This term comes from the Fourth Lateran Council in the 13th century. They possess an office, the office of judicial vicar or adjutant judicial vicar. They share in the judicial authority of the diocesan bishop, not properly, but vicariously. Nevertheless, their power is ordinary because it's attached to their office. Legislative authority at the local level cannot be shared. So the only person who is capable of legislating in a particular church in a diocese would be the diocesan bishop. At the universal level, we saw that earlier, the legislators would be the Roman pontiff and or the College of Bishops. Delegated authority, conversely, the other kind of authority that's exercised, is delegated to a person. So a person does not possess any type of office. Nevertheless, the power is conferred upon that person. The person is delegated for a specific act. So a priest may be delegated by the diocesan bishop, may receive the faculty from the diocesan bishop to administer the sacrament of confirmation to an individual. That would be delegated authority. The priest doesn't have any proper office. His power is for that particular circumstance, for that particular person, and it is delegated by the diocesan bishop to the person. That is delegated authority. So the power of governance is exercised in the church either by virtue of office, that is ordinary power, or to a person, and that is delegated. Let's go back, shall we, in conclusion, to Canon 15. Ignorance or error concerning invalidating or incapacitating laws does not hinder their effectiveness unless it is expressly determined otherwise. So, what is this law articulating? This law is articulating that the legislator does not presume that individuals are ignorant of the law or that they don't understand the law. The presumption is that people know the law and that they understand the law. In other words, the law's power is not contingent upon the subjective understanding or misunderstanding of a particular individual. If someone has been issued a driver's license by a state, and the person is operating a motor vehicle upon the roadways of the state, the person is presumed to know, to understand the laws of the road. If a person makes an error or a misjudgment and the police officer pulls the motorist over and says, you were not supposed to make a right turn at that intersection, and the motorist says, well, I didn't understand the road sign, the officer isn't going to say, oh, well then, okay, I'll let you go. No, the law presumes that the person, the motorist, since they're licensed, knows the laws and understands the meaning of the law. So the law's power, the law's force, is not contingent upon the subjective understanding or misunderstanding of the individual. Now let's look at these two terms for a moment, shall we? Ignorance or error. What do we mean by ignorance? Well, ignorance is lack of due knowledge. That's very important to remember that. Ignorance is lack of due knowledge. In other words, it's what we should know. It's what we should know. If a police officer pulls over a motorist and asks the person, do you know what the speed limit is here? That's a legitimate question. The motorist in operating a motor vehicle is required, is presumed to know what the speed limit is with regard to that stretch of road upon which the person was traveling. So, if the person does not know, then the person is ignorant, because the person, the motorist, was supposed to have known. So that's ignorance. Error is a false judgment of the intellect. It's a mistake. So, ignorance or error concerning invalidating or incapacitating laws, all right, invalidating again refers to the act, incapacitating refers to the person, does not hinder their effectiveness. So the law is still binding, unless it is expressly determined otherwise. Now, let's look for a moment at this issue of ignorance a bit further. Ignorance is divided really into two main categories: vincible and invincible. Invincible ignorance, obviously, refers to the fact that a person really would have no legitimate way of knowing the facts, of having the knowledge. All right? So, a police officer pulls over a motorist and asks the motorist, do you know what the Supreme Court decision establishing the precedent of the presumption of innocence was? All right. Maybe if the motorist were a law professor or a very skilled attorney, maybe the person would know. But a person in that circumstance, the ordinary motorist, would not be required to have such knowledge, to possess such knowledge. Indeed, that might be what we would categorize as invincible. Then there is vincible ignorance, where the person should have known, could have known. So we have vincible ignorance that is simple, all right? Some means of curing the ignorance were undertaken. We have ignorance, which is what we would refer to as crass or supine ignorance, in which no diligence whatsoever was used to cure the ignorance. And then lastly, we have affected ignorance. Affected ignorance. And affected ignorance is the direct intention to remain ignorant. That would be what we would call affected ignorance. We may see later on that these various species of ignorance may impact the person's culpability, pardon me, or lack thereof, relative to applying the law. So, what to remember from Canon 15 is that the effectiveness of the law is not at the mercy, if you will, of the subjective knowledge of the individual. The effectiveness of the law remains intact. Why don't we conclude with a prayer? Glory be to the Father, and to the Son, and to the Holy Spirit, as it was in the beginning, is now, and ever shall be, world without end. Amen. Thank you very much.
We hope you enjoyed the program and will join us back for another show on WCAT.